During the 20th century there were many trials in many countries that challenged the notion of censorship. HistoryRadio.org now takes you to one of those trials, the case of Fanny Hill, A Woman of Pleasure, by John Cleland, versus the state of Massachusetts. Fanny Hill was a book published in 1749, by the Englishman John Cleland. The following is an unedited 1965 segment from the USOS project that makes audio from the Supreme Court available under a Creative Commons license. But first, a short introduction.
Madam, I sit down to give you an undeniable proof of my considering your desires as indispensable orders. Ungracious then as the task may be, I shall recall to view those scandalous stages of my life, out of which I emerged at length, to the enjoyment of every blessing in the power of love, health, and fortune to bestow, whilst yet in the flower of youth, and not too late to employ the leisure afforded me by great ease and affluence, to cultivate an understanding naturally not a despicable one, and which had, even amidst the whirl of loose pleasures I had been lost in, exerted more observation on the characters and manners of the world than what is common to those of my unhappy profession, who, looking on all thought or reflection as their capital enemy, keep it at as great a distance as they can, or destroy it without mercy. Hating, as I mortally do, all long unnecessary prefaces, I shall give you good quarter in this, and use no farther apology than to prepare you for seeing the loose part of my life, wrote with the same liberty that I led it.
Number 368, the book named John Cleland's Memoirs of a Woman of Pleasure, appellant versus the Attorney General of Massachusetts.
May it please the Court. This is an appeal from a decision of the Supreme Judicial Court of Massachusetts, which held that this book was not entitled to constitutional protection by a 4-3 vote. I'm happy to say, Mr. Chief Justice, that I bring you a case in which it is not necessary to read the book. It's not that we don't want you to read the book. We urge you to read the book. We think it's a good book. We do not think it will adversely affect your moral fiber. We do not think that you will find it deeply offensive, although if the members of this busy court have not had time to keep up with the bestseller lists, you may find the subject matter a bit unusual. And on the matter of redeeming social importance, in this way, Your Honor, all counsel here I don't think your time was wasted, Your Honor. I think, as I say, that it is a book which has many values to offer the reader.
Well, then help me, because I haven't read it.
Very good, Your Honor. I will say this, though, if I may help the Chief Justice first. We have here a record in which there is an overwhelming demonstration of the kind of value that all counsel here today agree invokes the protection of the First Amendment. I would suggest that a possible answer to the administrative difficulty that the Chief Justice has outlined is that where you have highly qualified witnesses who come to court and stake their professional reputations on their analysis of the book and its values, where you have published reviews and critical essays by people who have no interest in the outcome of the litigation, which also establish that value. Then, on the record, the book is entitled to the protection of the First Amendment. The majority below, Your Honor, did not accept the test of redeeming social importance. They referred to it as one other possible test. It obviously made very small impression on them. And then they committed an error, which I believe this court will find to be an error on the basis of the record. They said the book has only minimal literary value. Now, this court, of course, while it may not...
I thought, Mr. Rembar, that expert testimony, if I get what you're saying, if a number of distinguished literary critics say this book has social value, that ought to be enough for us. But I gather they're only experts, aren't they? And if the ultimate decision is for us, I thought expert testimony was only to aid, not to decide for the ultimate fact or other determiner what such help as it may give. But I didn't think it could be substitution for...
I didn't mean to suggest the contrary, Your Honor. What I'm saying is this. You do not accept the conclusion of the so-called expert. He doesn't merely get up there and say, this book has value, and leave the court. And there can be testimony on the other side as well. It is for this court to read the record, to appraise the testimony, and to decide whether really a case has been made out for social value. The witnesses in this case didn't make conclusory statements. They analyzed the book. They spoke of the various canons of literary criticism that are to be applied. They found the book good under those canons. Now, in opposition, there was one witness, and we would leave to the court the appraisal of his testimony as well. He was a witness who spoke in conclusory terms. He called the book obscene and prurient. He said that prurient meant esoteric. When asked if that was really the word he meant, he said yes. When he was asked who it was that the heroine had married at the end of the book, he couldn't remember. He referred to Jane Austen as an 18th century novelist. Well, all of these things can be considered. At the same time, the court can consider the qualifications and the statements of Professor Fred Stocking, chairman of the Department of Literature at Williams College, Professor John Bullitt, professor of English and master of Quincy House at Harvard, Professor Holland of MIT, Professor Sprout of Boston University, and the rest of the witnesses.
Well, I might understand this if it were a problem in nuclear physics. But I wonder if that carries over in this area.
I submit, Your Honor...
point, Mr. Rembar, that simply as a matter of law, not as a matter of fact, but as a matter of law, if witnesses of this caliber and stature and good faith testify to this, then no matter how many people disagree with them, if there are those people that this caliber willing to testify and able to testify under oath to this, then no court could hold that this was utterly without redeeming social importance. Is that it?
Well, Your Honor says no matter how many people disagree with them, I would ask in court or out of court?
Witnesses. We're talking about witnesses under oath.
If there is a substantial body of expert testimony that says this book is utterly without value, then this court will make up its mind on the basis of that record, just as it does in other cases where there are disputes.
But our test has been utterly without.
Yes, Your Honor, and that is what the test will be. But in applying that test, you will have to consider the testimony on both sides of the case. It's conceivable that
So if you got one Baptist minister on one side and 1,000 on the other, you couldn't say that it's utterly.
The Baptist minister, I think, Your Honor, would not be qualified to give literary testimony. He might testify as to the religious value of the work.
Oh, I see what you mean.
But I would say in answer to
You could have a work could conceivably have redeeming social importance because of its literary value, because of its moral value, because of its
scientific, artistic. This court has mentioned those aspects. And
geologic, anything else.
But the minister might throw light upon redeeming social value, might he not?
he might, if the value of the book were urged to be its religious object,
his own therapy and counseling.
then it has a medical or a psychiatric value.
Yeah.
Yes, Your Honor, that would constitute that kind of value. But if I may return to your question.
I'd just like to get this clear now. This follows up with Mr. Justice Stewart. Are you urging on us that we say that where there is testimony directed to the issue of redeeming social value, and that is credible testimony of acknowledged experts in the field, that ends any obscenity case without our ever reading the material involved?
Yes, Your Honor.
That's what you're saying?
I am saying that.
That is well-written literate pornography is outside.
Your Honor, the word pornography.
Well, doesn't it mean that? We're dealing, I guess, by hypothesis with what's pornographic material, as to which, however, a number of acknowledged literary critics are willing to say it has some literary and therefore social value because it's well written.
If by pornographic, Your Honor, means sexually arousing or lustful in terms of decisions, the answer is yes. I think it has been clear for some time now that material whose effect is to stimulate a sexual response in the normal person is not for that reason to be denounced. I think that such material...
Well, Ross said that much, I think.
Yes, Your Honor.
Well, if you need an expert as to whether or not it has social value, expert in that field, why not go to a member of the legislature? Why wouldn't they make the best experts? They're the ones that usually pass on those kind of policies.
Because he's not an expert in that field, Your Honor.
He's an expert in passing on what proposals of law have redeeming social value.
But here, the assertion is not that the book has value as legislation. It's that it has value as a book.
That's right, but the policy there, the question of policy. And I would think no one would be better qualified to do that under our concept of government than the members of the legislative body. For assuming always that it doesn't violate the First Amendment.
Mr. Justice Black, suppose what was urged was not that it had literary value, but that it had scientific value, that it had great value in expounding the point. I beg pardon?
Get aside.
Yes. And if what is urged is literary value, get people who know about literature.
Well, is that limited to literary value? The idea of great social value?
Not at all, Your Honor. It can be many things. In this case, we say there is literary value, and we say there is historical value. In other cases, it might be another kind of value. It might be the kind of value that Mr. Justice Douglas adverted to. A value in helping psychiatric measures or counseling. There can be many kinds of value.
But the literary value, I just want to be sure I understand you correctly, is not because it has some special moral to convey. Is it only in that it is well written, well expressed, whatever the story may be that it tells?
There are, as elements of literary value, good writing, wit, observations of human nature, psychological insight, the drawing of character, the impression on the reader that there are real people involved in this. All these things are literary value.
Well, I just suggest to you, does that all add up to something well and powerfully written? Does it add up to anything more?
Well and powerfully, yes, Your Honor.
Yeah.
But the reason I was that detailed in answering your question is that we have encountered the argument that merely a good style is not enough. And I want to say that here we have much more than a good style. I'd like to return to Mr. Justice Stewart's question. If there is a substantial body of expert opinion that finds value, then I say the book is entitled to the First Amendment protection. It doesn't...
Because a court, as a matter of law, could not then hold that it was utterly without redeeming social value. Is that
Yes,
it?
Your Honor. But I am not saying that if one witness comes in and says it's a good book, that automatically answers the question.
You think it's clear, do you, as apparently your predecessors here today have, that the court has clearly established the test of obscenity as three component tests of appeal to prurient interest and utterly without redeeming social value and something that's patently offensive?
Yes, Your Honor. I think that is the necessary implication.
Where do you get that? From what cases?
Well, two of the tests from Roth. The patent defensiveness test does not have as substantial a backing because the Roth opinion was a majority opinion. And the opinion of Mr. Justice Harlan, in which the patent defensiveness test was enunciated, was not a majority opinion. But I think it is also true that the patent defensiveness test represents one branch of the prurient interest test as set forth in Roth. That is, there is, in addition to the kind of morbid and unhealthy appeal to a certain kind of sexual response, in addition to that, there is the idea of going substantially beyond customary candor, which I think is very close to the patent offensiveness test as Mr. Justice Harlan stated it.
This book was published first in 1774?
49, Your Honor.
1749. Then under your historical argument, I suppose anything that would now in 1965 show what people were thinking about or doing in 1749 would pass muster.
If it showed enough of it, Your Honor, there was testimony here that the book has historical value in two ways. One is that it formed an important part of the development of the novel. It came in that decade in which the novel, as an English literary form, was created. The other is that there is a great deal of material in the book about manners and customs at the time.
Showing how bad our forefathers were.
There is, in our brief, Mr. Justice Douglas, material showing that there is a rather acute parallel between the events related in this book and the events related in the newspapers at just about the time this book was published in connection with the Pro Fumo affair in Great Britain.
What's happened in England as a matter of interest? Has this book been
There's been...
banned or what?
I don't know the current status, Your Honor. There was a trial in which the judge, the magistrate, held the book obscene, and there was no appeal. I don't know what the situation is outside the jurisdiction of that magistrate.
In this country, it's been banned in Massachusetts, it's been allowed in New York.
That's exactly it. Those are the two states in which the case has reached the highest court. There was a trial in New Jersey which held against the book, and the appeal there has been held in abeyance pending the outcome of this case. I would like, if I may, to mention the brief amicus that was filed without consent of the parties, but with the permission of the court. That brief deserves special mention because I think it represents more truly than the brief of the Attorney General the nature of the opposition to this book. The brief proceeds from Curl's case. It cites that case 8 times. Curl's case was decided in the first year of the reign of George II. Curl was a rather rambunctious publisher who was hailed into court for 2 things he published. One was a book that the government felt brought the government into disrepute. The other was a book that the government felt was obscene. The court, in the obscenity case, decided that obscenity was a common law crime. And they had decided it on this basis. They accepted the argument of the Attorney General there that a breach of the King's peace is a common law crime, that a breach of the King's peace can come from writing. And he said it comes from three kinds of writing. Writing that tends to bring the government into disrepute, writing that tends to go against religion, and writing that tends to go against morality. The court agreed with him on all three. Now, I think this is extremely important because it shows exactly what the kind of opposition to publication is that is found in the anti-obscenity laws.
That reduces us then to books on mathematics and books on religion.
Books on religion would be bad under this test. But what I wish to point out, Your Honor, is that when the First Amendment was adopted, all three aspects of this opposition were rejected. They came as a package, and they were rejected as a package.
Was this book ever prosecuted in your publisher or dealer in the 18th century?
The author himself was not prosecuted. The bookseller later was prosecuted, but it appears that the book was not an authentic copy of the original. This book, throughout its history, has had sort of a reverse Baudelarizing. People have added things rather than taking them out. They've added illustrations, for example, and an illustration formed the basis of a case in 1821 in Massachusetts, in which a defendant named Holmes was convicted. I want to say one more thing on a question that was asked previously, and that has to do with the state and federal question. I want to call to the Court's attention certain practical considerations that should affect the legal conclusion. An author lives in one state. A publisher publishes in another. The book is printed and bound in a third, and it's distributed by wholesalers everywhere. None of these people observe state lines. In New Jersey, there was a stipulation that the book would not be distributed during the pendency of the case. Some books got into Camden because the Philadelphia wholesaler covers South Jersey. It is just not consonant with the realities of modern publishing to attempt a state-by-state censorship. We cannot have some states in which a book is published and others in which it is not. A publisher cannot gauge his ability to publish, which comes down to a matter of money, in that way. I would say that this nation cannot exist half censored and half free. Thank you.
We'll recess, sir.
Half censored.
Truth. Stark naked truth is the word, and I will not so much as take the pains to bestow the strip of a gauze wrapper on it, but paint situations such as they actually rose to me in nature, careless of violating those laws of decency that were never made for such unreserved intimacies as ours. And you have too much sense, too much knowledge of the originals themselves, to snuff prudishly, and out of character, at the pictures of them. The greatest men, those of the first and most leading taste, will not scruple adorning their private closets with nudities, though, in compliance with vulgar prejudices, they may not think them decent decorations of the staircase or saloon.
You have just heard an unedited audio segment from the U.S. Supreme Court of a 1965 censorship case concerning the U.S. publication of the 1749 novel, Fanny Hill, or the Memoirs of a Woman of Pleasure. The audio was published online under a Creative Commons license by the OIS Project. At the start and at the end of the show you heard the opening paragraphs from the novel. This is historyradio.org, a free radio stream promoting knowledge of literature and history.